The survival of President Obama's health care overhaul rests with the Supreme Court seemingly split over ideology. Chief Justice John Roberts and Justice Anthony Kennedy posed some tough questions to administration lawyers defending the health care law during 3 days of arguments that suggested they have strong reservations about the individual insurance requirement at the heart of the overhaul and, indeed, whether the rest of the law can survive if that linchpin falls. But Roberts and Kennedy also asked enough pointed questions of the law's challengers to give its supporters some hope. In any event, justices' questions and arguments don't always foretell their positions. And someone who would know this for sure, the Attorney General of the state of Texas, Greg Abbott, joins us. Mr. Attorney General, thank you so much for your time.
Hey, it's great to be with you. Thanks.
You really can't tell how a justice is going to vote by the questions they ask, can you?
No, you truly can't. Before I was Attorney General of Texas, I was a justice on the Texas Supreme Court, and I know firsthand that the comments that justices make from the bench sometimes could be misconstrued because there's different reasons why the justices make those comments. But that being said, if you look at the body language, if you look at the depth of the question, if you look at how forceful the questions and comments by the justices were, and the frequency and repetition of those questions, it lends itself to take away a couple of at least overarching principles, and that is there's an unabated commitment on the part of at least 5 justices, one of whom didn't talk, which was Clarence Thomas, but among the other 4 conservative justices, that they are committed to the principles of federalism, of liberty, and deeply concerned about the way that the individual mandate that compels Americans to go out and purchase a product is going to interfere with the constitutional structure of this country. And all those signs point to encouragement for states like Texas who brought this lawsuit with the hope that maybe this Obamacare mandate will be struck down.
Am I looking at the Supreme Court with rose-colored glasses when I say I would think that 9 justices would come in with an open mind, ready to hear the arguments, or does it not work like that?
Well, they come in with an open mind, at least with regard to applying the facts to the Constitution. But you have to believe that some of them come in deeply committed to certain constitutional principles, one way or the other. Mm-hmm. Some come in deeply committed to the constitutional principle of that Congress has unlimited authority and they can expand the size and scope of government under a uniform sense of government here in the country. And there are other justices who come in deeply committed to the constitutional principle of federalism and of a more limited federal government, understanding that there are certain authorities that remain in the states as required under the 10th Amendment. So different justices have different leanings based upon the Constitution.
I know Justice Ginsburg had mentioned that attacking this is akin almost to attacking Social Security. That if you're for that, you can't be against this. Are there comparable? Is this a comparable situation?
Well, we disagree with the construct because we believe that Social Security, as well as some other social-based programs that are good for the welfare of the people of this country, typically have been passed and implemented under a different clause of the Constitution that empowers Congress to pass laws, such as the tax and spend clause. And here's the truth that came up in these oral arguments, and that is the United States Congress had the ability to pass a tax and spend provision that would have imposed Obamacare. The Obamacare law initially was crafted and labeled as a tax. They changed that because they knew that it was political dynamite and they couldn't do it. They couldn't touch it. And so they reworded it, redrew it, and changed it from a tax to a penalty and imposed the individual mandate. And so there is nothing like this on the books out there. And that is also what the court admitted from the bench. This is an unprecedented case where there is no prior case law that dictates what the answer is.
And it was an unusual and difficult situation for the administration to have to argue one day it was a tax, the next day it wasn't.
Well, it was just one of the several occasions where the court itself, justices on the bench, pointed out the hypocrisy of the Obama argument, where one day they argue one thing and another day they argue another thing. And it just made it very, very difficult, I think, for the lawyers on behalf of the Obama administration to be able to present a strong case to the court when neither the facts nor the law were supportive of it.
Mr. Attorney General, I have about 30 seconds. I wanted to ask you, I know that justices of any court they're human beings. Do you think that they're influenced by outside, editorials, protests outside the Supreme Court building? Do you think that has any effect on their decisions?
Not directly. I think that they really are going to base their decision based upon their interpretation of the law and of the Constitution. They might be able to draw some comfort, at least the ones who may vote to strike down the Obamacare law. They may draw some comfort from the reality, and that is not only do a majority of Americans disagree with the Obamacare law, but a majority of Americans believe it's unconstitutional. And so even though it won't dictate what their outcome will be, it may provide them some comfort for those who vote to strike it down, that they are doing something that a majority of this country are strongly in favor of.
This is Greg Abbott, the Attorney General of the state of Texas, with us on America's Radio News. Thank you so much. I appreciate your time today.
Thank you.